Good day, Crime Talk aficionados. It's Saturday, and what does that mean? That means one thing. It's the weekly recap from Crime Talk, and boy, did we have a busy week. From the verdict in the Chauvin trial to the closing statements in the Chauvin trial, as well as all the other true crime news. Hope you enjoy a recap. Have a wonderful and safe weekend. First on the docket, the trial is finally over. The evidence has been presented. The jurors have been given the legal instructions in this case, and now they're sequestered and the jury begins their deliberations. Now, the prosecution's first closing statement of the day, frankly, lacked a whole lot of passion or enthusiasm, and I've said this before. The prosecution's first closing is usually pretty boring. Now, very competent attorneys, good attorneys, did they do anything wrong or bad? No, but it just kind of lacked a whole lot of passion. There wasn't any there. It went on for, I think, an hour and 15 minutes, and these are the elements. This is what we must prove. Look, we have brought you evidence. Believe our evidence. Find him guilty. That's kind of the way it is. The defense then got up to do their closing. Mr. Nelson, the defense attorney for Derek Chauvin. I've said this all along. I think he's done a very good job. You understood his theory, his defense, and he pulled it through. I think he went a little too long. I kind of blame the judge for that. Apparently no time limits were really given. And I think had the judge said, I'm going to give you an hour and a half, get it all done, he would have got it done perhaps a little more succinctly. However, the defense made their argument. They made their points. Why do you say, Scott, that he made his points? Because the prosecution got up and, as some of you, if you stayed for the entire proceedings, once the jury got their charge to go back and deliberate, there was a hearing held afterwards. And a motion was basically made for a mistrial regarding statements that were made by the prosecutor in not only their first, but particularly their second closing. It amounted to prosecutorial misconduct. The prosecutor cannot use the words, the defendant is shading the truth, cannot say that they are spinning stories, coming up with stories, because that implies that they're lying. Prosecutors cannot do that. The judge sustained all but one because it was the context of it in the first closing wasn't probably improper. But in the second closing, when the counsel got up and repeatedly said stories, and then said, well, I'm just trying to say stories are, spinning of the truth, shading of the truth, completely improper. And guess what? Why would a prosecutor do that if you think your case is so great? Don't do anything that's going to push it. Why did they do that? Because apparently, I'm going to guess, the people in the room can see the jurors. And they must be taking notes, writing down what Eric Nelson is saying. And for the prosecutor to get up and push it to the point where you could cause a mistrial, not only now, but have the case reversed on appeal for that, you must be worried. Okay, the judge read the instructions and the law to all of the jurors out loud. We were all able to watch it here on the live feed as well. And the reality of it is the prosecution has some hurdles to get over. Do I think that the hurdles will be so large that the prosecution cannot overcome them? I don't think so. But the question is, the defense only has to raise reasonable doubt, because the prosecution basically has to prove that Derek Chauvin, by his actions, was the substantial. And substantial means basically pretty much everything, the cause. And what is the prosecution's theory? That George Floyd died of asphyxia. We brought in the pulmonologist. We brought in everybody. But their own doctor who did the autopsy, the one who did their autopsy, said this wasn't a strangulation case. The defense highlighted that in their closing. And he said, listen, if you don't think that a man who has fentanyl of 11 nanograms, that has methamphetamines and blocked arteries of, I think, 75%, somehow couldn't have a really bad day, guess what? You're ignoring common sense. And what the defense had to say was that former Officer Chauvin acted as a reasonable police officer would, and he pulled from all of the prosecution's own witnesses, agreed that what Derek Chauvin did was in fact reasonable, and said this wasn't a chokehold, that he was following his training. He was authorized to use this level of force. Reasonable, because that's the standard in these type of cases, what a reasonable officer would have done. He walked the jurors through it. This is the case where if the jury wants to find Derek Chauvin guilty of something, they can hang their hat on some of the evidence that's been presented. If they want to say, I have doubts, there is plenty of evidence for the jurors to say that they have doubts. So now we all wait and see. Certainly, once we have word that a verdict has been reached, we will try to bring the verdict live and see what the result is. It's going to be very, very interesting. Now, that little hearing that was right after the jury got their charge to go deliberate, the judge had to deal with another issue, and that was the Congresswoman Maxine Waters, who just happened to show up in town. Of course, that's not her district she represents. I think she represents a district near L.A., and basically what she said was that if there's anything less than a murder conviction, that people need to be more confrontational with the police. Now, the judge made a comment. He, first of all, denied the motion for mistrial, but he did say to Mr. Nelson, Maxine Waters, Congressman Waters, may give you what you need for a new trial if there is a conviction. Okay? Now, Maxine Waters, I'd like to refer to her as I can't believe Waters, right? Because I can't believe she said it. Everything she says, I think, is just sometimes unbelievable. I can't believe she said it. And then I can't believe that people continue to vote for Maxine Waters. Anyway, we'll see if there's a conviction and if it gets reversed because of what she said. Now, hopefully we can have this little snippet for you where the judge says, I wish public officials would stop commenting on this case, that they should respect the co-equal branch of government and the constitutional authority that they have, because, they all took an oath to support and defend the Constitution. So let the judiciary do their job. Clearly, Judge Cahill has little tolerance for politicians and perhaps particularly Maxine Waters.
I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational, but you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot.
We'll wait and see. I think it's going to be an interesting story. A lot of a lot of true professionalism shown on both sides in this particular case. Clearly, the prosecution had a lot more resources. I think 5 attorneys that they had in the courtroom at any given time. And then there was Mr. Nelson on his own. Looks like maybe he had some research or some sort of paralegal in the back. I've only done a 3-week trial twice in my days, and I can tell you I'm exhausted. I'd be exhausted. I'm exhausted after a 1-week trial because most people don't realize that it's not just an 8 to 5 gig, and that when you get done with court that evening, you go home and prepare for the next day, even though you think you've already prepared, because nothing exactly goes as planned. Things come out. You have to anticipate. You're preparing for the next day, future witnesses. It's literally about a 16 to 17 hour day when you're in trial. So we'll wait and see. It was a good defense by the defense, and even if they're convicted, that's good. We want Mr. Chauvin to receive a great defense so that if there is a conviction, it stands up on appeal, right? We'll see how that turns out, and hopefully the city won't burn. Whatever happens, respect the verdict. Next on the docket, why can't Lori Vallow and Chad Daybell be brought to trial? And the reason why I bring this up is the matter of Derek Chauvin was brought to trial in less than 1 year. The incident that involved the death of George Floyd took place on May 25th of 2020. We are not even 1 year into that entire matter, and guess what? We've already had a trial and the jury is deliberating. Then let's take a look at the Lori Vallow matter. Charges were filed in the Lori Vallow Chad Daybell matter on June 10th, specifically relating to the concealment and the death of JJ and Ty Lee. Clearly, we're not going to make a trial within 1 year. Why? Because the defense has yet again moved for another continuance, and they say that they are not prepared to go to trial, and they're going to set a motions date, a status date in June to set an actual trial date and motions date. Why do I bring that to your attention? High-profile cases need and require strong judges. The judge in the Derek Chauvin matter was clearly a strong judge. He set deadlines and people complied. It's the old adage, the job expands to the amount of time given. If you set deadlines, it forces people to make decisions. If you don't set any deadlines, people think, well, nothing bad is happening, so let's just wait it out. We have talked about how the defendant has a statutory and constitutional right to a speedy and public trial. Well, one thing that people often forget is the state, right? The state or the federal government has a right to a speedy and public trial too, so that the people can have resolution to these matters. That's why speedy trial is so important. Now, I get it. This is the biggest thing that's hit Idaho in a long time, but the reality of it is, I hope the judge starts putting his gavel down and says, these are the deadlines. We're not changing them unless there is some sort of act of God, and we are not moving these dates. Deadlines won't be extended, and attorneys, you're not getting off this case. So if you don't have the funds and resources to do it, you better get off now, because after a certain date, speak now or forever hold your peace. Try to lighten things up just a little bit. I think this is what will do it. First, Mark Means commenting for Court TV and held out as an experienced criminal defense lawyer. Ha, I know. Isn't that kind of funny? Okay, in all seriousness, Court TV was having a segment regarding what the criminal defense attorney, in this case, Mr. Nelson, would feel like after losing a big case. Well, Mark O'Mara, who was also on this panel, along with Mark Means, Mark O'Mara is an experienced criminal defense attorney. You may say, where do I know that name from? He represented George Zimmerman, but he talked about what we in the defense world sometimes refer to as trial psychosis. You get into such a zone that you actually think, I'm going to win this thing, even though you probably have zero chance to win it, but you do that to get into the zone, so to speak. Mark O'Mara said he's going to, the defense attorney is going to be, beating himself up. Did he ask the right questions? What did he do wrong? He's going to be just frustrated by the whole thing. Then when they get to Mark Means, basically all he says is, well, the other side brought in the, but they had 5 Michael Jordans, referring to Michael Jordan, the basketball star, one of the greatest of all times, and basically saying that the defense, was all by himself. He's a one-man show. How is he possibly going to compete? And the only thing that Mark Means could contribute to this conversation was the government has more resources.
Mark Means, when I look back at the trial, Eric Nelson was almost like this one-man band from beginning to end, the only one, kind of like Mark O'Mara said, directing all the witnesses, crossing all the witnesses, a lot of work. At one time, he actually seemed fatigued during the trial and just coming through, but not with this outcome that he wanted. If you were in this, would you be licking your wounds today, I guess is my question.
Well, the first thing I say is part of that speech that you didn't show is the AG came out and said, hey, we had a team of Jordans. And that's in reference to Michael Jordan, the greatest basketball player of all time.
Duh. Welcome to the world of criminal defense. When it says the people of the state of whatever versus the defendant, or the United States of America versus the defendant, they mean that. And they mean all the resources that come with the government. That's why when you win a case in criminal defense, it is a big deal. The prosecution is supposed to win. They have all the good facts. They have the resources. They're supposedly have this case where they think they can ethically prove it beyond a reasonable doubt. They're supposed to win. So when the defense wins, it's a big deal. So a little surprised that Court TV would have Mark Means as an experienced criminal defense attorney because, well, if you've been watching this channel, you know he's never done a felony until this case, at least according to the district attorney prosecuting the Lori Vallow and Chad Daybell matter. Maybe they couldn't get a hold of anybody else. Another discovery disclosure has been made by the district attorney in the Lori Vallow and Chad Daybell matters. And coincidentally, this disclosure was made roughly about the same time that Mark Means was appearing on Court TV yesterday. You can see our video from yesterday, complaining about all the resources that the government has. My position on that is, what did you think you were getting into when you were doing criminal defense? Okay. Needless to say, Mr. Means should have stopped the public appearances and got to work. Apparently, there's discovery that he can come and inspect. Apparently, all of this evidence has either previously been disclosed, but the district attorney is double-checking, triple-checking to make sure it's been disclosed so that there are no allegations that they haven't received this information. Now, normally, these type of disclosures are done informally. And the fact that the government is doing this is simply to say, we don't trust the defense in this particular case because all they do is whine, cry, and cry foul that we're not doing something appropriately. So there you go. You have it now, Mr. Means. Go get the discovery and get to work so you can be prepared. Since we're supposed to have a jury trial, and now all we have is a status date to get a trial date. And I don't understand why we have to schedule it all the way out in June. Like, nobody can find 30 minutes on the court's docket the entire month of April or May? Really? Come on, guys. Let's get this case rolling. The circus continues in the Lori Vallow, Chad Daybell matter. And I think maybe the judge is just about getting tired and had enough, and he has set a hearing for April 28th. Now, how did this all come about? Was it perhaps maybe the judge was watching CrimeTalk and said, hey, maybe that Scott Reisch knows what he's talking about, and I, as the judge, need to put my gavel down and make sure everybody knows I'm in charge, and let's set some dates. Well, we'll find out on April 28th, and we'll bring it to you live, but a lot of these seem to be happening in chambers, but hopefully it's held in public. But let's give you a recap. So yesterday, Mark Pryor filed a motion, and he is opposing the use of and a motion to preserve DNA samples. He also filed in this motion to photographic recording of serology samples and other visual tests, motions to review lab records. Well, what does this really mean? The district attorney put the defense on notice and said, hey, we are going to do some consumptive DNA testing. What does that mean? That means that the DNA samples that the lab people have been able to collect will be consumed in the testing, and therefore there won't be a sample for the defense to do independent testing. You may say, oh my gosh, this is outrageous. Why is the prosecution doing this? Are they trying to use up all the evidence so the defense cannot have their own independent expert? Not exactly the case. The point is DNA can be very small and very small amounts, and it can be consumed in testing. It's not uncommon when it comes to a lot of serology as well as DNA testing in the lab. What does that mean? Normally, the defense would like to have a sample so that they can have their own independent testing done. However, if it's consumptive testing, there can only be one test done. Is the judge somehow going to say you need to cut your sample in half and save half for the defense? No. What the judge will more than likely do in this particular situation is say, listen, Mr. District Attorney, Mr. Wood, what you're going to do is set a date certain for this testing to begin, and the defense, you can have your expert attend, and therefore they can observe all the cutting of the material where the DNA is going to be coming from, as well as the entire process to make sure that it is done in accordance with all the laboratory standards and procedures. Issue resolved. Happens all the time. I think the real issue is that the defense probably doesn't have an expert, and if they do, it's more than likely going to be expensive. And I can't imagine the attorneys are going to come up with this out of their own pocket, assuming their client doesn't have the financial wherewithal in which to pay the DNA expert. Now, the defense is also asking that all of the reports and what they refer to as bench notes be preserved. That's always done, and usually when you get a DNA packet, you get the bench notes so that you can have your expert review those bench notes to see if there's anything out of the ordinary. Now, Mr. Pryor filed the motion, but who could make it even more ridiculous? That's right, Mr. Means. So he files a motion stating that he is joining the motion filed by Mr. Pryor regarding the same issues. And then he goes into, and this is where it gets good, a copy of a midnight correspondence to counsel from the prosecutor in this matter. And what did he do? He had the audacity to CC, that's right, CC the court on this email as well. Now, Mr. Means then accuses the prosecutor of engaging in ex parte communications. What? How can it be ex parte if you are CC'd on the email? If the prosecutor was emailing the judge without your knowledge, that would be ex parte and completely improper. But the prosecutor doesn't do that. In fact, you can see that on the email. Anyway, Mr. Means goes on and says, it appears that the prosecutor is attempting to backdoor communications methods to potentially protect himself from a Brady violation. Finding of this court based upon the prosecutor's continual refusal to provide full and complete discovery responses, these direct, improper ex parte communications are potentially making this court an unnecessary witness in future litigation. What? He further goes on to say that he may seek relief from the court because of this unnecessary ex parte communication. I do not know where Mr. Means went to school, but clearly somebody has to explain to him what ex parte communications is. As you can see, it is a letter to Mr. Pryor. It's an email with a letter attached, and it has the court, Judge Boyce, and it has Mr. Means as well. That's not ex parte. So here's the letter. Take a look at this letter. Tell me if there is anything improper about this. I see nothing. It's a letter to Mr. Pryor, and it states, I'm including Judge Boyce and Mr. Means on this correspondence because I'm following up on the matter that you brought up during our recent conference on April 7th. You mentioned at the conference that you are estimating you're missing 30 items into discovery. The prosecutor then goes on to state, you've never told me what you're missing. You make these allegations, so we're following up. So the court ordered the prosecution to get them what they need to find out what is missing. As the prosecutor notes, I've given you everything except for Tammy Daybell's autopsy report, which the Fremont County prosecutor has not provided to him. Therefore, he can't provide it to the defense. The district attorney goes on to say, I'm a little surprised by your statement in court that you were missing such a large amount of items because we've basically checked and double checked and you've received everything. Now, this kind of goes along with the conversation that we had in yesterday's video. This is why the prosecutor is filing notices with the court on something that's usually done informally, because both the defense attorneys in this particular case have repeatedly accused the prosecutor of misconduct. He's just trying to cover his butt to make sure there is no appearance of impropriety. Now, Mr. Means, of course, follows up in this letter, and my God, somebody needs to get this man someone to proof his letters. And I understand we can all make mistakes when it comes to a typo. You get fast, you get lazy, but it seems to be a trend here. Here in this letter, Mr. Means states, I joint in Mr. Pryor's objection regarding consuming all remaining DNA samples and testing. Okay. And then he goes on to basically say, once again, painting a big overreaching broad brush, saying your office continually appears to have intentionally and wrongfully withheld this discoverable information / documents to date for unreasonable amount of time. Maybe you want to get a little spell checker and Grammarly. I highly recommend Grammarly. Don't get endorsed or anything like that, but it really helps you with your sentence structure. I do not understand why this attorney is always so overreaching. He has to be losing credibility with the court. You resolve discovery disputes informally. You request them, you put them in a letter, and when they tell you no, drop dead, we're not doing it, then you go to the court. So now we have a court that can't seem to get anything done because everybody's fighting and bickering over discovery. This sounds more like a civil case, which maybe some of the attorneys are more inclined to do and be, than a criminal defense attorney, which is simply, let's go try this case and let's get it over with. The circus continues, ladies and gentlemen. All right. Thanks for watching. I hope you all had a great week. Have a wonderful and safe weekend, and we'll see you next week on Crime Talk.